folks, I know there's a history here. I'd like to get this hearing in today. You know, everybody needs to just focus on the relevant facts, okay? I know there's a history here.
Are you talking up by Sunset Mart? Up the hill by the gas station?
Yeah.
Okay. Why did you? All right. Who's responsible here?
What's that?
Who's responsible here? Whose house is this?
Whose house is this?
You haven't been drinking or anything, right?
No.
Okay. Drive careful, okay?
Thank you.
What is everybody? Happy Friday.
The runaway.
Oh, really? You just ditched it? Awesome.
Yeah, those ones kept walking in the car. And the other one.
It's Truly's for the win.
Trulies. Fuck 'em up Fridays. Welcome to the transparency.
That I was given to. So there was 2 different discs. Okay? They all knew about it.
We're not here to talk about the alcohol stuff, okay?
Okay, yeah.
But this is the second noise complaint we've had here tonight within 2 hours.
How are you?
Good, how are you?
Good. Is this your place?
Yeah.
Perfect. You know why we're here?
I see noise.
Noise, yeah.
Yeah.
Big speaker right there.
Yeah.
Nothing against having a party. Once neighbors start calling in, then we have an issue.
Like brains, and like if you need a lot of brains, you're gonna.
What is up, everybody? Welcome. Happy Friday. Cheers. Let's do this. Good to see everybody. Thank you, moderators, for being here. Let's see. Water's everywhere. So I've been working on a master timeline. I'm going to be releasing this right before January 23rd, so on the 22nd. I'll have it in a PDF form, so those of you guys that are going to be following along for the January 23rd hearing, if you're a member, you'll get the PDF form. So members get perks. They get high fives and loves and hugs, but they also get perks. So there was filings that happened back at the end of December, and they were just uploaded last night. And the first one that we're going to talk about is on December 31st, the state, they filed their objection to the defendant's motion to compel material and for sanctions. This information is really, really interesting as it gives us S1 to S25 of exhibits that has to do with experts. And then, so that's one of the documents. And then in order on 1/7/2025, it's like a week later, then the defense replied to the state's objection. And so we have that as well. Basically, we're going to start off with a bang. But as far as these two documents go, somebody's not understanding. So I said someone is lying. When I say someone is lying, what I mean by that is that misunderstanding. Hey, we need this information. You're not giving us all of it. We want these reports. We want to know what they're testifying to, so that when I say we, the defense is saying that, like, hey, we over here, you're giving us stuff, but it's not enough to be in compliance with the discovery rules set by this court as far as the expert disclosures, and then that follows the Idaho rules. I think it's 16B 6 and 7. So we're going to go over all of that. But before we do that, actually, I'll wait to the end. We'll do this first. So stick around, get a bomb at the end. This won't be that long. All right. And then after the filing of the defense's reply to the state's objection, the defense filed like basically simultaneously an extension to give their experts based on the fact that the prosecution didn't disclose adequately. So you guys can be the judges. Here we go. There were sealings stipulated to, which was exhibits S1 through S25 by both the defense and prosecutors. But really quick, so the sanctions is because, hey, you're not getting us our stuff on time and you're not giving us everything that we need. Let's hear what the state has to say about this. This is the relevant facts. So they changed their terminology here to relevant facts, background facts. Now it's relevant facts. The state has been actively engaged in replying to the defendant's request for discovery, because this is what they're asking for sanctions, including materials related to potential expert witnesses, since the original discovery request was filed on January 10th, 2023. As ICR 16J contemplates, discovery involves a continuous duty to disclose which the state has and will comply with. The specific continuing duty to disclose evidence that ICR 16 compliance is not a one-time event, as we know. Let me go like this. There we go. So defendant cites over 68 terabits, and state does not dispute this. The discovery received by the state from multiple agencies has been provided to the defendant in the same manner in what it was provided to the state. So remember, Ann Taylor makes a little remark that, this discovery is just all over the place, and pretty much it was what Richard Allen's defense team was saying as well. So that's the first little, hey, we provided it the same way that we got it. Next up, the state is in the same position as the defendant in this regard. So just like how you guys got it, that's how we got it. So we're in the same boat. And I just find that comment absolutely ridiculous, but this is the footer with that. Defendant complains and appears to represent that he has not been provided with adequate information from the state. This is patently untrue. By way of example, to appreciate the true degree of analysis and use by the defendant of discovery that has been provided, the court need look no further than the extensive detail in the defendant's motion for a Franks hearing. The 20-plus supplemental discovery requests and related materials, and the many other detailed substantive motions he has filed. I think that's interesting to word that way. Basically, the state's position is look at all the shit that they have. We've provided that to them. They have all of that because we've provided it to them. Okay? And I believe that the defense's position is 95% of that shit, if not 99% of that shit, is nothing that you guys are intending to use. And actually the stuff that you're intending to use against my client has been buried in it versus just saying here you go. Here's the stuff that focus here, but here's all this other stuff that you asked for. Okay. That's basically how I'm seeing two different people talking. And I would just think that if you built a case around Brian Koberger, you have certain evidence, right, that you did all that. And that should be just readily at your fingertips, right? Well, the answer to that is half right, half wrong, because how much of it was other agencies? And you hear the prosecutor just repeating himself saying, this doesn't exist, or we don't have it. We don't have it. Then it went from this doesn't exist to then we don't have it. We're not in possession of it. Okay. So those are your two arguments. What the heck is going on with this computer? Hold on one second. Okay. I'm closing out some stuff. Hold on. It's ridiculous. All right. Okay. So moving on. So again, the state's saying that they're in the same position as the defendant in this regard. The court record will reflect that the state has provided extremely detailed responses to the defendant's request for discovery and motions to compel above and beyond what is required by Rule 16. On December 18th, 2024, the state, in compliance with the court's order, filed its guilt phase experts consistent with ICR 16b7. These disclosures were filed 7 months and 24 days before the commencement of trial. It's funny that she wants to talk about and mention that it was, 7 months and 24 days. Yeah, that's the deadline. Okay, the deadline. You filed it on the deadline. Now, Judge Hippler set this deadline. All right. Judge Hippler set this deadline. So awesome. As of the date of this filing, we are 7 months and 12 days before the commencement of trial. Well, again, Judge Hippler sent all these deadlines in which I agree with the state, and I agree with Ann Taylor here. These are so far out from the trial date. They truly are. Okay? They truly are. Especially the motion in limine. Nonetheless, defendant argues that he has been prejudiced and requests sanctions. Well, we'll talk about that. Defendant's arguments are without merit. Now, this is now the state's argument. The state has complied with the court's order in Idaho rules 16b7 regarding disclosure of expert witnesses. On December 18th, the state filed state's supplemental response to request for discovery regarding expert testimony in compliance with the court's unredacted sealed order governing further. Remember when they had that closed hearing? Because I went back and took a look. There were a couple dates that got shifted in that closed hearing. So that's why she's mentioning this and why we can't see this. But that order's stated as follows under Section C, discovery and expert disclosures. And it says here that experts, a list of the parties intended to be called at trial, including a copy of the expert's report consistent with ICR and a copy of the CV. Okay. Those are supposed to be to the opposing party. So the state's guilt phase experts, December 18th. And so they filed it on the 18th. The order refers to ICR 16b7, which states in relevant part, which is then here, on written request. So Ann Taylor's team would have had to write in a request stating, to the prosecutor, they must provide a written summary or report of any testimony that the state intends to introduce at trial or at a hearing pursuant to Rule 702, 703, 705 of the Idaho Rules of Evidence. The summary provided must describe the witness's opinions, the facts, and the data for those opinions and the witness's qualifications. Okay? So this is what Ann Taylor is expecting to get. The defendant cites, so when I read for you guys before, hey, the sanctions, I did it I think it was like last week. I read off them just citing a couple cases to say like, hey, we need this stuff. This is case law. So here, Ashley Jennings is saying the defendant cites this case, State versus Morin, in support of his motion. Defendant's motion to compel, page 3. Morin was charged with driving under the influence of drugs. The state filed the following expert disclosure for the forensic. So the state filed the following expert disclosure for the forensic toxicologist in that case. Okay. Because in this case, guys, guess what? We're going to get to see some evidence here, which is pretty cool. All right. Oh, Truth Nation's in here. Look out. Hold on one second, guys. I need to pop out and pop right back in. My screen keeps flashing. So let me do something really quick. Leave studio. Okay. There, let's try this. So in that case that they cited, Dr. Dawson is an expert in toxicology and pharmacology and will assist the trier of fact in understanding the evidence regarding the effects of drugs on the behavior and performance of the defendant as reported in this case. Dr. Dawson will utilize known and general accepted scientific principles of absorption, distribution, your metabolism, just this is what was said as a summary of what this person was going to testify to. State versus Morin. Dr. Dawson testified that dilated pupils, confusing speech patterns, impairments to balance, and other psychomotor function, lack of convergence, and green coating of the tongue were all diagnosis indication of marijuana intoxication. So again, this is just talking about this other case. The courts held that the state's response disclosed nothing more than Dr. Dawson's qualifications. The generic response vaguely described the subject matter, not the content of Dr. Dawson's anticipated testimony. The court held a mere list of topics or general subject matter which an expert witness may testify is not a discovery response. So this is what Ann Taylor was saying that y'all did. Okay. And they're citing this case. The court also stated, even if the state did not know all details of Dr. Dawson's testimony at the time of the initial discovery response, and then said right here, which is ICR Rule 16, imposes a continuing duty to supplement the response if a party later discovers or decides to use additional evidence. Discovery rules are drafted to safeguard the truth-seeking functions of a trial. The rules are designated to promote fairness and candor, facilitate fair and basically expedite pretrial fact gathering, and prevent surprise at trial. So by way of contrast in state versus, so then the state talks about the state versus Koch or Koch. I don't know how they pronounce it, but I know a girl that she said, I pronounce my name Koch. So whatever. And so they talk about, this case. So Koch argued that above disclosure was insufficient because it failed to disclose Yeager's opinions and facts and data behind those opinions as required by ICR 16b7. Koch or Koch also claimed the disclosure was insufficient because it did not include a summary or a report written by Yeager. The Idaho Supreme Court disagreed. So they get into here, you guys have to remember this. These are lawyers being lawyers and basically saying, I'm smarter than you, going back and forth. And then here's a judge that's refereeing their throwing their dicks on the table type of, here we'll measure you up. Okay. But the Supreme Court disagreed. The Supreme Court held that the disclosure informed Koch or Koch of the main opinion to which Yeager was going to testify. And while it did not specifically disclose that Yeager's opinions were based on her training and experience, which would be better practice, it did provide her CV that presumably disclosed her education and experience. Okay. So we're going back and forth here between the state and the defense team saying that, hey, the defense is saying, you guys gave us a list of 25 people, okay? And you're supposed to give us a summary of their opinions, the facts, the data. What are they going to be testifying to? What are their opinions of, just because you give somebody a report, and the report, like, let's say, is the toxicology, all right? Well, here's the toxicology results. Okay, this is what this person's going to testify to, the toxicology report. Okay, so they're going to testify to, yep, here's a toxicology report. Here's this person had this in their system, this person had that in their system. But the question is did you say, is the person going to opine that this person couldn't, function, or when that assumption, what, that's great. You're reading from a piece of paper from the lab results. Okay, awesome. But what else can you tell me because of the piece of paper? Because of the results? What's your opinion? And it's pronounced Cook. Anyways, so that's kind of what we're dealing with here. And they're going back and forth on these two cases. So Ashley Jennings is saying, further, the Idaho Supreme Court held that the state does not have to produce a written report where none had previously existed, stating, if there is no data, the state doesn't have to produce data. Okay? She is simply an opinion witness. Okay, well, what is her opinion? Noting that Koch could object if the testimony varied from the state's disclosed summary. The Idaho Supreme Court and Koch discussed the scope of ICR disclosure requirements and looked to the federal rule of criminal procedure. The Supreme Court noted that the main difference is that the federal rule requires the basis and reasons for those opinions, whereas the Idaho rule requires the facts and data for those opinions. Can you guys believe this? This is wild. So in one sense, so if you're going based off of the federal rules, we need the basis and reasons for your opinions. Okay, whereas the Idaho rule requires we just need the facts and the data for those opinions. But do we need your opinions as well? So, suggesting the federal rule requires broader disclosure. The Idaho Supreme Court further noted that the experts' conclusions were adequately explored by defense counsel on cross-examination. So this is the state's argument, is that in these cases, especially the Koch case, is that the Supreme Court decided and ruled that the defense was able to cross-examine and wasn't affected by whatever disclosure or non or lack of, all of the disclosure, but that the defense counsel on cross-examination with no particular difficulty, evidencing that the state's disclosure was adequate. So we're not going to know until after the trial, right? If they were able to adequately cross-examine, and who's saying that somebody could adequately cross-examine? Like, how do you determine that? Who determines that? Because I'm guessing in your appeal, when you're going to be if you were to write up an appeal, this really needs to be noted for appellate attorneys to say that you really need to go hard at this whole, could, the trial lawyer properly cross-examine? Because I've seen this now in so many, rulings within the appellate court. They keep talking about, is or was the defense able to cross-examine, So anyways, just pointing that out. But the goal of Rule 16 is to provide the opponent, see, they're making it a game here by even saying it like that, to provide the opponent with a fair opportunity to test the merit of the expert's testimony through focused cross-examination. In State versus Casewell was charged with possession and delivery of methamphetamine. The state discovered a report by the criminalist Donald Wyckoff, who tested the controlled substance and determined it was methamphetamine. At trial, Caswell objected to the introduction of this report, claiming the state failed to, quote unquote, provide him with the working papers or graphs from which Wyckoff drew his conclusions that the tested substance was in fact methamphetamine. 5 months before the trial, the state provided Castle with Wyckoff's report, Exhibit C, containing his test results and conclusions. The state did not provide the working papers and graphs on which the conclusions were based until requested at trial. So on appeal, the Idaho Supreme Court found that the state's disclosure Exhibit C was adequate. So a lot of this stuff back and forth right here, you guys, this is all about, this is a death penalty case. So this back and forth is literally is for the defense to be able to say, we're not going to have any issues on appeal here. Like, we're defending our client to the best of our ability, and we're asking that the state provide us with everything now, and so that we don't have issues down the road. Okay. The state should only want to try this case once. But what I see right here is boiler. Okay. Until you possibly we're going to get a little deeper here, but right here, whatever. Now, turning to this case at hand. So now we get to talk about the Kohlberger case. Turning to this case at hand. On December 18th, the state disclosed 25 potential experts. Now, the reason that she says potential, as you will see here, is that in an abundance of caution, the state included witnesses that the state does not, quote unquote, like label as technically experts within the meaning of ICR 16b7, but anticipates that the defendant might disagree. So what basically Ashley Jennings did with these 25 people and Bill Thompson is, we're just being cautious to say, if you try to say down the road, if we wouldn't have said that these people are experts, and then the defense tries to say, well, they didn't disclose these people and they're experts and they were supposed to disclose that to us out, back in January. Okay. Or I'm sorry, December. So here, Ashley Jennings is saying the reason that we've listed these people is because we're not going to deal with down the road the, Ann Taylor and company trying to say like, well, so-and-so is an expert and they didn't disclose that to us. So she's like, I'm listing them as an expert, but we really don't think that they are, but we're not going to hear it down the road. Okay. So where are we at here? Okay. The defendant takes issue with 22 of the disclosures claiming they are insufficient. So out of the 25, 22. All 25 of the state's disclosures comply with the court's order and ICR 16b7 and are not the quote unquote generic discovery responses as presented in Morin, which the defense cited. All 25 disclosures encompass more than a mere list of topics of general subject matter which an expert witness may testify. So in Morin, it says each disclosure informs defendant of the main opinion. So, okay, great. What's the main opinion to which each expert will testify, and the CV which that opinion is based upon as required by Cook or Couch. So for experts where the state does not have a report, as further held by Cook, in that case, it says, if there is no data, the state doesn't have to produce data. Okay. So the state addresses each objection to the proposed disclosures as follows. So this is where we get some juicy information. So this is the best part now about this document. And that's, here we go, for exhibits S1 and S6. The state disclosed expert opinions, plural, regarding the toxicology results for basically all the victims, as detailed in the provided toxicology reports. Okay, so Ashley Jennings is saying the toxicology reports, all right, that's where the opinions lie. Well, I'm just going to throw an example here. In the Brian Drake case, or other cases where I've seen toxicology, okay, reports, like from like the lab, here's the results of the toxicology test. And then here you go. Here's the piece of paper, and it lists, yes, no, how much is in your system, shit like that, right? But never once have I seen then someone's opinions on the report, on that typed out report of, so for example, in the Brian Drake case, he was he had what, 0.08, which is legally drunk or whatever. Like you couldn't drive a vehicle. Well, where's the opinion found in that report of when and how much, like, consumption? And when did this person consume this? How quickly before death did this person consume this alcohol to be at, that level at death? Right? So just, I'm trying to just show you that as an example. So here, basically the issue that I see, the defense is saying, is that, okay, for exhibits S1 and S6, the state disclosed experts' opinions regarding the toxicology results. So if you're just saying this person was drunk, this person was high, or this person had this in their system, this person had that in their system, and this person has this in their system, and there's nothing else there, like, that's all I'm testifying to is to doing the test, and this is what was in their system. I don't, so is that's what the defense is basically saying, because here, results for all the decedents as detailed in the provided toxicology reports. Then it says, in addition, the state included the toxicologist's CV, which supported his/her opinions. Your CV makes you qualified, okay? Included the toxicologist, like, wouldn't that be apostrophe S there, by the way? Like, or are there multiple people that did this? Well, shouldn't that be apostrophe S if it's just one person? So I'm curious if that's why, for example, exhibit S1 and S6, the state disclosed expert opinions regarding the toxicology. I think that there was two. I think that they used two people. Okay, so I'm noting that for you guys. So two, which is supported in his or her opinions. This disclosure was not merely a topic list of general subject matter. Well, so it'll be interesting. They're going to say they were so intoxicated that it was an easy kill for BK in a short time, in my opinion. Yeah, well, if that's there, if that's written. Now, but how are you to base that off of, like, you have to say that. So based off of this toxicology of this person, this person, this person, this person, and the order in which they were killed, okay, I believe that this person, I mean, at this type of a high level, let's say like Ethan was off his ass, like hammered, okay, like he was just drunk, okay, that, you know, so that their motor skills, anybody that we've ever seen like this, their motor skills, like they're, you know, even though their phone was right there, they were so, like, they were passed out. They weren't with it. I'm just throwing all this stuff out there. But basically what the state is saying and what the defense are saying are two different things, because the defense is claiming that, and we'll get to that because the defense has a reply here. So, but the state's saying that we disclosed this, we gave you the toxicology reports, then we gave you what I believe is going to be two toxicologists and their CVs, which supported his or her opinions. And I just think that they mean that they're allowed to opine on this. They've been deemed an expert and they've testified in all these other cases type of thing. Okay. So we get to, instead, this disclosure was not merely a topic or a topic list of general subject matter, which the expert may testify as precluded by Morin. Instead, it is the main opinion and the CV which supported the opinion as required by Cook in that case. So as noted by the Cook court, the Idaho rule is not as broad as the federal rule, which requires the basis and reasons for those opinions, whereas the Idaho rule requires the facts and the data for those opinions. You see what I'm saying? So they're saying, here are the facts. This is the toxicology report. Our opinions are based off of those reports. So now, states S1 and S6 disclosure satisfy the requirements of rule. Boom, boom, boom. And so we're moving on then. Then the state says, okay, for exhibit S2, the state disclosed special agent balance. The state's disclosure was adequately specified. For example, so S2 has to do with Nick Balance. S1 and S6 have to do with two separate toxicologists. Special agent Balance, in quotes, it says, Special agent Balance will provide his opinion as the general locations in which the target cellular telephones is plural, were located at various times before and after the homicides at 1122 King Road, and the cellular phones directions of travel, end quote. And so I was thinking, okay, well, what are those opinions? The attached report detailed the target cellular phones, in plural, analyzed, the dates analyzed, and the direction of travel. So the attached report details that. So we have Nick Balance is going to testify to cell phones. And then here you go. Here's this report. And so what this is my guess is I've seen what a CAS report looks like. So I'm guessing this is CAS, right? And in a CAS report, just so we're all clear, I've never seen a CAS report. Maybe if it was just a draft that I've only seen, but I've never seen, I've seen, this is the area that the cell phone was in when it made these two calls. And one call was at 7:45 and one call was at 7:48. And then, but it doesn't say that. It just says this number called this number, time and time that it, how much time it was. Then at 7:48, this number called this number. This is how much time it was for. And then it shows you the target area, and that it gives you this circumference of where it was. Okay. So that's what I seen. But then we get to right here. In addition, defense was directed to the cell phone records provided by AT&T and the drive testing files, which supported the report. The defendant appears to be requiring compliance with the federal standard, which is much broader than ICR. The state's disclosure provides defendant with adequate notice of Balance's anticipated testimony to satisfy the requirements. So, anticipated testimony. And so basically it's like this. Here, we don't know what Nick Balance is going to be testifying to, but here's this CAS report. Here are the cell phone records from AT&T. Here's the drive test. Give it to your your expert, and I'm sure he'll know everything that, he's going to imply. That's how I see this. Whereas what the defendant is asking for is, what is your opinion? Is your opinion, so then you would write up a report. My opinion is that the cell phone at such and such time was over here, and then it did this, and then it did that. Is your opinion, so then I'm over here thinking to myself, why isn't Ann Taylor just deposing these motherfuckers? I get that you're supposed to get all this or whatever you think you're supposed to get. Awesome, great. I don't give a shit though. Okay, play your games, do all this. But I am deposing every single expert witness that they intend to call, right? Because I want to know what they're going to say on the stand, right? Unless you're telling me, well, I can't do that. And I don't see why I can't. So also, when we're talking about the cell phones, I know people in chat are asking, are they implying that Brian had two phones? Are they implying, you guys, we have no idea. We'd be speculating to say that. But my guess would be that it could be actually, it's saying phones, plural. So Balance will provide his opinion as the general locations in which the target cellular telephones were located at various times before and after the homicides at 1122 King Road. And what I believe, this is just my opinion, this would be the surviving roommates, because everything goes on them. So you got to make sure that they're home, right? You got to make sure those surviving roommates were home, right? So they could see whatever they said that they saw or heard, whatever. And Brian's cell phone. So I'm guessing the two surviving roommates and Brian's cell phone. That's my opinion. Again, strictly my opinion. Now, for exhibits S3 and S4, the defendant correctly agrees these disclosures meet ICR 16b7 requirements. So we don't know who these are in reference to. So for exhibits S5 and S7, the state disclosed two likely fact witnesses as experts out of an abundance of caution and was clear about this intent. The defendant's argument that the state erred in this good faith disclosure is without merit in the event either of these witnesses are in fact experts within the meaning of ICR 16b7. It is clear from each disclosure exactly what these witnesses will testify to based upon the provided disclosure. Now, this to me is the I'm going to call it the X factor. Okay. This one has my piqued interest. These two likely fact witnesses. Okay. Fact witnesses. We'll come back to that. For example for exhibits S8, the state disclosed the vehicle identification expert, Special Agent Imel. The disclosure specifies he will testify to his use, so pay attention, to his use of the forensic audio, video, and image analysis program. When people out there say to me, Lana, how can you possibly tell the difference between a 2011, 12, 13, 14, 15, or 16? Okay, well, I want to highlight this again for you right here. It is 2024. Okay. They have programs, but I'm also telling you, it's like people that collect baseball cards, people that have certain hobbies. If you are a car guru, I'm sorry, but you can easily spot out if the mirrors are supposed to be black behind the mirror, or if it is actually the color of the car because it's this year, then they change that. Or the headlights are different now. They're in different locations. They're square versus circle. I mean, there are so many, if you have good surveillance and it's not like a blob on the screen, you're going to be able to tell the difference. But here, this guy is going to testify to his use of the program. And then the forensic audio, video, and image analysis program, he's going to testify that it was used to determine the make, model, and year of a suspected vehicle involved in the 1122 King Road burglary and homicides in Moscow, Idaho. I straight up circled this for a really, really, really important reason. Okay. Because it says, and year of a suspected vehicle involved. Okay. So he's going to testify that he used this program. He's going to testify to his use of this and how he was trained and all that crap. And then Ashley Jennings says, it is clear from the disclosure that this witness is an expert in vehicle identification. Okay, great. I don't think that they're saying that he's not. The defendant has repeatedly been provided the images relied upon, which are detailed in his report of examination, which was attached to the state's disclosure, CS8A, page 1. Now, this is Ashley Jennings. This is where it's interesting for all of us. And I love it because what Ashley Jennings is saying here is that we've provided you with how Emil made his identification, meaning the material. And we now know that when Jay Lodson says he relied upon a still image from Ridge Road at a time, at the wrong time, going the wrong way, okay? You're going to argue that in court. But that still holds true here, though, that, yep, that's what we provided him, okay? And so he's basing his just, hey, what did they show you? Okay, so you base your decision off of this. And then it's going to be the defense's job, okay, to show to the jury, if it gets to that point, that it is irrelevant or that the state has not made like that car going that way is not the same car as such and such. Okay. I think that's what the defense is basically saying is, so he's not going to testify to the fact that that's the car that did X, Y, and Z. You know, that's how I'm seeing it. Like when you just, okay, read it as it is. And what is it telling us? And so the defendant has repeatedly been provided the images relied upon, which are detailed in his report of examination, which was attached to the state's disclosure. Now I'm going to tell you, the date that they have for this is March 21st, 2023. The date of that guy's report, okay, is dated that, which is well after the arrest, okay? So the state's disclosure provides defendant with adequate notice of S.A. Immel's anticipated testimony to satisfy the requirements. So they're being this is where it's just like, okay, so this is all you're going to give us. If you're going to, what do you think you're going to do on the stand? Just that. This is the vehicle I was given. When were you given this vehicle to look at? You put it in the program, and this is what it popped out. And it popped out 2011, 2013, right? Okay. And then, so what image then were you given to readjust the 2011 to 2013 if you use this program? Were you given the same image and then it just popped out 2011, 2016? Like another time? So this is going to be great right here. This right here is going to be great. For Exhibit S9, Karen in chat just made 20 members, or I should say 20 subscribers, very happy by making them members. Woo, 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 woo. Hi, Karen. Happy Friday. If you happen to snatch up a membership, let Karen know. Woo, 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 woo. So, basically what the defense is trying to get is, okay, well, where's your report? Like, to say, okay, I am Special Agent so-and-so. I was contacted on this day and asked by so-and-so to look at so-and-so and da-da-da-da. Like, that's not what the defense was provided. The defense was provided, defendant has repeatedly been provided the images relied upon, which are detailed in his report of examination, which was attached to the state's disclosure, CS8A, page 1. And his opinion is whatever the year is that it pumped out. That's it. That's what I'm gathering, just so we're clear. And so he'll just be asked these questions on the stand, like, so you weren't asked to sit down and like use surveillance and like follow these cars all over, or they just simply came to you and said, hey, can you help us identify this vehicle? And who picked the image that you would get? Did you ever say, hey, do you have any other images? Is this the only thing you have? You know? Things like that. That's what's going to come out, like during a trial. So moving on, for Exhibit S9, the state disclosed Kathy Mabutt, baby. Kathy Mabutt, labeled an expert witness. Did you guys know that Kathy Mabutt has 44 years experience as a nurse? She is a registered nurse, as well as an attorney, as well as the elect coroner I mean, Kathy Mabutt does it all in motherfucking Moscow, baby. Okay. So, the Latah County coroner, the state specially detailed each opinion to be proffered. So, the opinions were supported by the attached death certificates authored by the coroner and the coroner's CV. The defendant fails to mention that in addition to being an attorney and an elected coroner, Ms. Mabutt was a registered nurse for 44 years, which is detailed in her CV. And I'm going to tell you why this is important. Because this is all about the time of death, baby. Time of death. Well, time of death. Now, I'm going to tell you what they did in good old Indiana. In Indiana, with the Delphi case, they didn't take temperature. They didn't do anal anything, okay? Because they couldn't do any of that because they were doing SA kits, okay? And they did not want to disrupt anything. And so the range of the time of the crime, or AKA, I should say, not the time of the crime, but the time of death, was a 40-hour range. 40 hours. Okay? And they attributed that to that we didn't take temperature. We didn't. Now, I think it's going to be interesting because in this case, the Idaho4 case, they came out and they said that there was no sexual assault. Okay? So I'm curious, did they do SA kits on the victims to come out and say that? They said that pretty early on, like the next day, like the 15th or so. I swear, I think that they said that they were, if it was before the 17th, it was before the autopsies were done. So here, basically the defense has issues with how is Kathy Mabutt determining a time of death? That's what I see. This is just, again, my opinion of reading the documents and interpreting it in my brain. Okay. But when they want to talk about this right here, like the defense, Ms. Mabutt was a registered nurse for 44 years. So she was a nurse while she was an attorney, while she was the coroner. I mean, does nobody else work in Moscow, Idaho? That people have to have 3 jobs? Sounds like Key West when I lived there. So Ms. Mabutt was a registered nurse for 44 years, which is detailed in her CV. The state's expert disclosure satisfies the requirement. So now we're moving on for Exhibit S10, S13, and S14. So these 3. The state disclosed forensic detectives. They use the word forensic detectives. Well, just so we're clear, Lawrence Mowry considers himself a forensic detective with the Moscow Police Department. That's his label, forensic detective. So, I cited that here to say, well, Mowry considers himself a forensic detective with the MPD. So these 3, 1, 2, 3. So my guess is that we're talking about 3 people because of how they did, the S1, S6, when they're talking about what reports and stuff. Anyways, I could be wrong, but detectives is in plural. S10, S13, and S14. The state disclosed forensic detectives. These disclosures specifically listed each forensic item to which the witnesses would testify regarding, period. Is that even a sentence? So these disclosures specifically listed each forensic item to which the witnesses would be testifying regarding. That is not a proper English sentence. I Tell me if that's proper. I need to go home. I just need to stop. Or am I just, that cannot be proper. Anyways, the witnesses, see the apostrophes right now, expertise in the process of extracting and identifying the data. So this is where you realize, hey guys, we're dealing with digital forensic experts here. Exactly, Kate. Regarding what? Exactly. This is, I don't even, period. I'm sorry, but the witnesses' expertise is the process of extracting and identifying the data. So that's like Micah Sturgis. And no, that's not a disarray. Okay, that's not what disarray does. That is on each of the listed devices. Now remember, there were 67 devices taken, just so we're clear. But don't think for a second that they did anything with all of those. All right. The contents of each of these devices that are mentioned in S10, S13, and 14 have been disclosed to the defendant. Any opinion related to that extraction, i.e., whether a connection, so for example, whether a connection was found or not, is not an expert opinion. So Ashley Jennings is like, listen, these are our 3 experts that we had to get because there's just so much shit we had to go through. So we have 3 different experts that are in digital forensic. You know, they work with Celebrate, they work with Axiom, whatever, and they, you know, extracted these phones and they made these PDF files for each of these devices. That is, here's all the extracted data. Okay, here's all the extracted data, and then you're supposed to be forming opinions from the extracted data, like, okay, on Thursday, so-and-so texted their mom and said, I'm going to go eat Subway. Because you're going through the list of text messages or whatever. But here, Ashley Jennings wants us to all know, for the public, that none of these digital experts, so right here, any opinion related to that extraction, i.e., whether a connection was found or not, meaning like that person to Brian Kohlberger, that is not an expert opinion. As a result, the disclosures meet the requirement. So, Jesus. Okay. This is my comment to that. And just to pose them. Again, for exhibit S11. So we're dealing with 3 digital experts, by the way. Forensic phones and shit. But for exhibit S11, defendant correctly agrees. Check. So whoever that belongs to. For exhibit S12, the state disclosed an expert on crime scene reconstruction and bloodstain pattern analysis. The state specially detailed each opinion to be proffered. To be proffered. Interesting way of putting it, just like how they put my butt, to be proffered. So the state especially detailed each opinion to be proffered. The opinions were supported by attached reference report and CV. The state's disclosure provides defendant with adequate notice of this expert's anticipated testimony to satisfy the requirements. As noted by the Koch court, the defendant has identified areas throughout the disclosure for cross-examination which only evidence the adequacy of the disclosure. Defense should be able to cross-examine with no particular difficulty, satisfying the goal of Rule 16. So clearly the defense has said, in regards to the crime scene reconstruction and the blood stain pattern. Clearly the defense has said, what is the opinion? You know, is this blood stain a transfer? Is this transfer? Is this, you know, whatever, man. Exhibit S15 through S25. Like these would be like my things with the crime scene reconstruction. Who died first? Who died second? Who died third? Who died fourth? Right? You're getting that information based on the results of, well, we might not be able to tell if Kaylee or Maddie was killed first because like maybe their blood is kind of, it's all mixtures. But I would think the wound, there has to be some wound or one of the wounds that would only consist of, you know, there wouldn't be a mixture if they swab certain areas. I mean, who knows how they did this? You guys, I'm telling you, if they did this like they did the Drake case, this crime scene is going to be a fucking shit show. They suck. Idaho State Police forensic team is garbage. Absolute garbage. Absolute garbage. Brian Drake, his back was covered in dirt, soil, and vegetation all over his sweater. He's laying on a perfectly clean carpet. Where did Brian Drake get all of this crap on his sweater? Nothing to see here. The team decided that the bullet was a downward. It was downward. It entered at a downward angle. The ME said that was an upward angle penetrating wound that went through 2 ribs. So the state's case is not backed by the ME in that Drake case. Woohoo! Karen, $999. Woo! Karen. Happy fucking Friday. Cheers. Cheers, Karen. Cheers. Cheers, cheers. What currency is ZAR? It's just, it's in millions. So it's actually 999 million. ZARs is in millions. We just play that it is. All right. That's so funny. I love Karen. Karen, we love you. Thank you so much. So going back over here to this, where was I? Oh, yeah. You know, were these wounds like, I mean, it's going to have to come from the ME, but okay. S15 through S25. So now these 10 items, or these 10 reports rather. So we'll see. So right now it's 10 reports. I mean, they're saying exhibits. I'm guessing they're like, there's 10 items. So it's going to be, I'm just saying 10. So exhibit S15 through S25 all relate to Idaho State Police forensic lab experts. Ding, 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 ding. Ding, 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 ding. So first, the defendant claims not a single DNA expert opinion or report was produced. This is simply not true, says Ashley Jennings. In each of these responses, the state refers the defendant to specific lab reports and the corresponding Bates numbers. So wait, the defense wasn't wrong, right? You're directing them to Bates numbers because you want them to go look in the discovery to find this, or was it disclosed somewhere else during this pre-trial? So that's what they're saying. The defendant apparent argument that the state is required to make duplicative disclosures is unsupported. A single reference to where defendant can find the report is adequate. Wait, what? You guys, like, think about that. Think about that. Okay, so basically what you're just saying is that this has been turned over somewhere somehow, and that's why it's in Bates numbers, blah, blah, blah. And just, hey, these are the references, go get them. So each report provides a basis to determine what each report provides a basis to determine what the expert's opinion is through the referenced lab report. Again, think of a lab report. Think of when you go and get a lab report. Okay. Here's your blood work. Okay. Awesome. I don't know what the fuck this means. Hey, doc, what's your opinion on all of this? And then they tell you what your results mean, right? They tell you. Right? So, but here it is. Each report provides a basis to determine what the expert's opinion is through the reference lab report. As an example, the state is attaching Bates, look at this, 9,323 to 9,354. So what, 21 pages? For the court's review of how these disclosures comply with the requirements of ICR 16b7. See Exhibit S1 attached. The state follows suit in disclosures S16 through S20, and then doesn't mention S21, but then says, and S22 through S25. The state's expert disclosures regarding lab experts satisfy the requirement of ICR 16b7. For S21, I believe that this is the sheath. This is just my personal opinion. The state disclosed, ooh, look at who it is. She runs that bitch. Rylan Nowlin. As an expert. We've heard that name before, guys. It is anticipated that this witness is actually a rebuttal witness who is prepared to testify regarding secondary transfer if necessary. So then this got me thinking, okay? Because if S1 disclosed her for this, okay, who did the work with S15 through S25 minus S21? Because I'm curious, but I don't think that it's her. Anyways, all relates to the Idaho State Police Forensic Lab experts, and I'd be right. But she's the big daddy. She runs this shit. Don't you think that the way that this happens in Indiana, I'm just telling you guys, I just sat through that damn trial. And one person worked on every single piece of evidence in the Delphi case because she testified that no, there is no, that way we don't deal with, I believe this, to testify regarding secondary transfer if necessary. What do you think secondary transfer means? It means when somebody gets a little sloppy in your lab is what I believe it means. Hey, we're dealing with all of this. So all of our DNAs are in the system. So if let's say that we get like an unknown, all right? And so is it going to come back that one of these unknowns actually then tested against the ISP database, and it actually, one of those was one of the forensic team people that were working on at the scene. So again, maybe she is in part of this, but then they listed her just with this. But you don't have to, like, your rebuttal witness is not needed right now. So I don't know why you're talking about this now. Okay, it's kind of weird. But for S21, the state disclosed Rylene Nowlin as an expert. It is anticipated that this witness is actually a rebuttal witness. Okay, so maybe actually what she's going to be is she's going to be a witness up here with some of these, and then she's actually going to be a rebuttal witness, because what they're anticipating is Ann Taylor has a witness, an expert, that's going to be talking about something to do with this S21. And that's what I'm saying. A witness who is prepared to testify regarding secondary transfer if necessary. Basically trying to say that the sheath that for Brian's DNA to be on there could have been planted. Remember the word placed. Placed. You know, also, what about the fact that what if Ann Taylor has an Emmy that's going to say, well, how in the world does that sheath not have any blood on it? Not have any, it was laying on Maddie or under her body, and her, you know, just a single source on the button snap, but it's in a bed of blood during supposedly I don't want to say a struggle, but like, I mean, someone killing two people in this bed. So anyways, so the state contends the notice provided is sufficient pursuant to Rule 16 B7, but reserves the right to amend this disclosure upon review of the defendant's guilt phase experts and pending discovery disclosure. So that's a look at basically, and when you talk about, I'm sorry, but what the state, what I'm gathering from the state is they're going to make this seem so simple that Brian just went in there and did what he did, left, made a mistake. The sheath came out, and that's how, we got him. Like, that's what they think. But you guys know how many pieces there were? I don't know. I guess S10 through S25, but you can have there was 113 pieces that were tested. So if they put 10, if they gave, I don't even know. I'm not even going to think about it. Moving on. I'm going to be dropping my bomb here, but right before that, really quick here, a week later after Ashley Jennings says, here you go. This is our objection, okay, to the state's objection to the defendant's motion to compel material and for sanctions. Well, here you go. That was on 12/31. Then on 1/7, here's the defense saying, this is our reply to the state's objection to the defendant's motion to compel. And what they did is file at the same time, basically. This one was at 5:52 p.m. This one is at 5:52 p.m., 1/7/2025, because they filed a motion to extend time to disclose defendant's guilt phase experts. But first, we will show that Mr. Colbert is protected under the Constitution of the United States and the state of Idaho to a right to a fair trial, to confront his accusers, the presumption of innocence, and effective assistance of counsel. In an effort to protect his rights, the Idaho Supreme Court has pronounced rules governing criminal discovery through Idaho criminal rules. Mr. Colbert asserts the state's failure to disclose expert opinions and supporting data violates his rights under both constitutions. Mr. Colbert cannot fairly confront the evidence the state intends to bring against him when he does not know what it is. So again, even after reading, the reply, the defense says, are you out of your mind, basically? Mr. Kohlberger cannot fairly confront the evidence. So that's what they're saying is, how do you want us to confront the evidence when he does not know what it is? His counsel cannot be adequately prepared to represent him at trial, given the state's lack of adequate expert disclosures. Failure to properly disclose expert opinions by merely disclosing a list or topics an expert may testify about, or leaving open-ended, and see, that's what I liked, which says, or leaving open-ended opinions, in essence, shifts the burden to Mr. Kohlberger. What a great way to say that. And you cannot do that. So his defense is basically saying, you're shifting the burden. Okay? Brian Kohlberger is to be presumed innocent. They built this case against Brian Kohlberger because he is the killer. And this is how we know that he is the killer. We have all of these things. Here they are. This is what we have against you. This is what our experts are going to be testifying to. Bada boom, bada bing. Here it is. The defense is saying you have not provided us with that. So Brian, he is forced to respond to unknown expert opinions. And I'm curious as to what is unknown. With unspecified scientific, technical, or specialized knowledge, while giving the state the ability to disclose its further or actual expert opinions in rebuttal, filing on February 13th, 2025. So this is what I'm trying to say. Like, are they playing games? Come on, man. This failure to disclose, and also what they're saying is Brian Kohlberger has to, okay, so they disclose their experts with their opinions. Here, this is the case we have against you. Then Ann Taylor sees that and says, okay, that is not what happened, and that's not what that says. We need an expert that's gonna, testify to that, not like the opposite opinion, basically. Okay, think about a false confession expert. So what they're basically saying is that you're putting out this list, no opinions. I shouldn't say no, scraps. But you want us to then disclose our experts, and then you're going to then put in a bunch of rebuttals to our experts. And that's that filing deadline. This failure to disclose expert opinions not only prevents Mr. Kohlberger from confronting evidence against him, but also prevents him from asserting his need to file motions in limine and motions to exclude expert witnesses who do not meet the Idaho evidentiary standard rules of evidence 702, 3, 4, 5, and 6. Otherwise known as a Daubert hearing that Karen Reed's going through right now. Okay. I thought that Idaho wasn't down with that yet. Deadlines are looming. This motion cannot be heard until January 23rd, 2025, the actual defense deadline date. That is the deadline date for the defendant to get in his experts, is this date, which is the huge big day. So motions in limine are due February 10th. I mean, this is just crazy. And a motion to extend time to file some is filed simultaneously. I think this is a typo. I don't know what the hell these lawyers are doing right now. They're just seeing red. Like, see, basically what I'm saying, you guys, one side's lying. That's how I see it. Or I don't even want to use the word lying, but like, this is all we have to send. Look at, we're abiding by this. We're abiding by that. Just because you've given the defense 52, 68, I don't give a shit how many terabits or whatever. If it's all shit, it doesn't matter. It doesn't mean like, look at, we're complying. Look at 21 requested. What do we keep doing? We keep sending them stuff. Well, I think it says a lot more that they have to keep asking and that you're able to even send stuff. that means that you don't think it's relevant, right? You think Ann Taylor is asking for irrelevant shit? You think that they have time for that? No, Ann Taylor's asking for stuff in ways to prove that there's probably more shit. Listen, they can say, hey guys, it's all tactical. Well, you're not entitled to this. You're not entitled to that. You're not entitled to this. Then maybe our rules need to change if I'm so wrong to think that anybody would be entitled to this. If you got me by the balls, okay, then you got me by the balls. But it's like kids fighting over like the ham sandwich and that somebody got more than the other kid. The court has the state's sealed exhibits S1 through S25. The state's filing consists of over 400 pages, mostly CVs, because they're always long, of the named witnesses, and very few details of expert opinions with a few exceptions. That's what they're saying. And I think that you would have some balls to lie about this if this is not true. Because do you want Judge Hippler to say, like, you don't want him to think that you're misrepresenting anything in paperwork, right? Isn't that going to piss off a judge? I know that would piss me off, and I'm not even a judge. Approximately 2,000 pages of discovery are referenced in the DNA disclosure. What? 2,000 pages. The court does not have the discovery pages in the expert disclosures, but for one example attached to the state's objection as S1. Most of the disclosures have catch-all phrases that the expert will rely on the work of an unnamed others. What? That the disclosure is meant to be an aid, but does not encompass all findings, impressions, conclusions, or materials related to this expert's involvement in the case, or that the disclosure does not in any limit the scope of the expert's testimony. This language essentially places no limits on the testimony of the expert and places Mr. Colbert at a disadvantage because he cannot prepare for the unknown opinion of an expert that would be proffered for the first time on the witness stand in front of the jury. Exactly. And nobody in America, okay, is going to tell me this is, if you think they're lying about this, then I think they should get in trouble for it. But that's exactly what the papers that I just read said. And I think that I can comprehend. The state's disclosures violate his constitutional rights under the 6th Amendment and 14th Amendments to confront and cross-examine the witnesses, confront the evidence that the state intends to present, and his counsel's ability to effectively prepare. Some of the expert disclosures are extremely broad and encompass topics that are not touched upon in any reports or discovery provided. Right there. And I think with that, I believe, you know who I think this belongs to? My butt. I think my butt's with the good old boys. Who's my butt's husband? I think this one right here is straight up talking about my butt. That's just my gut feeling. My guts with my butt. These disclosures do not allow Mr. Colbert to evaluate the scope of the opinion, assess how his own expert witness will need to respond with countering opinions, prepare to confront the evidence the state intends to elicit, allowing counsel to competently prepare for trial, and determine if a motion in limine or motion to exclude will be needed. Other disclosures contain lists of areas of testimony without more. Mr. Colbert has provided no clues about the expert opinions on discovery disclosures that are vast. Hundreds of thousands of pages. Attached as Exhibit B under seal is a more detailed argument related to the lack of disclosure for specific experts, and they agreed to seal that. That was kind of them. The state's objection to defendant's motion to compel IRC acknowledges its duty under the rule, the quality of 68 terabits of discovery, and the disarray, and they acknowledge the disarray to which the state has both received and produced the discovery. So that's awesome that, we're also going to talk about this. How could this be in such disarray if everything was like, you're taking these emails, like you're just, dude, they were updating every single day, well, almost every single day, tips and emails and digital imaging and blah, blah, blah. Like, if you're able to talk about that, that means you were categorizing this shit. That means that you were doing what you were supposed to. And bring Lanier up there and put his ass on the stand and talk about what Lanier told everybody about how awesome their command, their chain is over there. Okay? But you want to know what they could say? Let them say it, though. Yeah, I was just saying that to appease the people. Because you're allowed to lie to us, right? Well, guess what? Just get him up there on the stand and make him say it. Make all these people say that every day they typed up a press release was a fucking lie. Okay? Just make him say it. Because then I have one thing to say. Well, then how do we know that you're telling the truth now? Period. You're so used to lying every single day. But we're supposed to believe you now, right? These jurors who are the same people that you lied to. Right? But we're allowed to. I don't give a shit if you're allowed to. Or you could turn it and say, exactly, you're allowed to. You get accustomed to it, don't you? But we're supposed to believe you here today, right? No, it's a tactic. It's a tactic. It's a tactic that they teach us that. It's a tactic. Say it. Exactly. It's a tactic. Because scaring and deceiving and backing people into corners, those really get truthful results. Because that's why the Innocence Project exists, right? The state interprets the motion to compel as one of complaint that adequate information has not been provided. See footnote 1, page 2. As a point of reference, a single terabit is the equivalent of 75 million pages of text. Mr. Culber's argument is that. It's an argument. Given the overwhelming amount of discovery in this capital murder case, should I add, okay, this is not a drug case of methamphetamine, somebody was popped with meth while driving. Compliance with discovery rules related to expert opinions is vital. To be informed of expert opinions being offered against him, Mr. Kohlberg's experts need to know exactly what opinions and supporting materials each of them is confronting in this case. Because that's what you're supposed to do. You're supposed to provide experts with, here, this is what this expert's opinion is, and this is the material that they're gathering that expert opinion from. What's your take? And here's the material, that they use to rely upon these expert opinions. The information. What is your take? We're not going to disclose what our expert opinions are of stuff first by meeting this deadline on December 23rd, right? And then you guys going and getting rebuttals then to our experts? Are you on fucking crack? If you guys don't think this is a game, this is a game. It's a game that Judge Hippler's a referee of. Mr. Culber's experts need to know exactly what opinions and supporting material each of them is confronting in this case, as well as allowing competent representation by counsel. Imagine that. Imagine that people want competent representation. He needs to know what scientific, technical, or specialized knowledge the witness holds to qualify him or her as an expert. Saying my butt was a nurse for 44 fucking years, I'm sorry, but I personally don't give a shit. You know how many nurses I think are fucking jackasses? But you know how many hot nurses there are out there? Telling me that I have a temperature and telling me what my vitals are when I go in. All right. Wait for the doctor to get here. Wait for the doctor to get here. The discovery rules are designed to safeguard the truth-seeking functions of trials, promote fairness, and or to facilitate fair and expedite pretrial fact gathering, and to prevent surprise at trial. Yep. Remember, Ashley Jennings said the same thing. The expert witnesses the state discloses are all relying on underlining data and technical or specialized knowledge, but what they intend to testify about using such knowledge is unknown. And if you're going to sit there and tell me that you think that this woman is going to lie about this and risk her career, I'm going to tell you that I think that you are kidding yourself. Like, that is absurd. Okay? That is absurd. Now, here's this little unknown footer here. The state submitted Exhibit S1 to its objection as an example of discovery that qualifies as an expert report. This exhibit is a list of items collected. If the witness associated with this list is simply a chain of custody witness, like I just said about a half hour ago, like, what are you going to testify to? Oh, hey, yeah, I did this. This was brought to me on this day, and I tested these items. Or, you know, as an opinion is not necessary. If the witness will testify that evidence was collected in ordinance with her training, proper procedure, and lab protocols that calls for and qualifies as her opinion, if the witness testifies that others gathered evidence in accordance with proper procedure and protocols, that also qualifies as an opinion. The lab protocols and evidence collection procedures have not been disclosed. If the state wishes to elicit her opinion regarding whether or not evidence was collected in ordinance with her training and lab protocols, that is an opinion. It is an opinion if you did it the right way. That is your opinion. So you're going to testify to, this is what we did. And the key word here is, damn it, where is it? So if the witness associated with this list is simply a chain of custody witness, an opinion is not necessary. You're just going to talk about the dates that you got stuff, that you signed this, that you did this. Okay, boom, shada bing, bob, boo. Awesome. But if the witness will testify that evidence was collected in accordance with her training, proper procedure, and lab protocols, then yes, that all calls for and qualifies as her opinion. I love it. I love it. I love it. If the state wishes to elicit any results of the tests and what they mean exactly, like the tox, okay? That is an opinion. This is a good example of how the state disclosure related to DNA are lacking in this case. So, helping clarify for everybody to know, an expert opinion, if you're just going to tell me what you did, awesome. If you're going to tell me that what you did was based on you being trained, based on it being by protocol, and that it was proper and all that shit, your training and experience, and it's your opinion that you did it by the book, that's an opinion. you're going to give me your opinion. You're not going to give me a list of what they say items. Absolutely crazy. Here, this is the list. This is what they're testifying to. What? What does that even mean? I wish I could see all this shit. Anyways, here's the boom I'm going to leave you guys with, keeping it right. So if you guys are waiting for, yeah, exactly. So if you guys stuck around for the boom, here it is. I want to talk about this lovely Amazon search warrant that was done on May. Let's turn to the right page that I want. Here we go. Affidavits of warrants, Maori. Okay, here's your bomb. Explosion. It's not letting me write it. Let's see if this will work. Okay, there you go. So Lawrence Maori here. Hold on. There we go. I, Lawrence Maori, being duly sworn that I am employed by Moscow Police Department. There you go. Forensic detective. Affidavit has been, or the affidavit has been a trained. I just can't. Okay. On May 8th, 2023, I obtained a search warrant for Amazon. Okay. I want to bust this all down for everybody. So remember, they did Amazon in connection with this case way earlier. All right. But this one is from on May 8th, 2023. And this date is really important. Okay. The warrant was served on May 10th, but I obtained it on May 8th. And it was served by Amazon, this LE. On June 27th, F.A. Douglas received the requested dates. On July 5th, I received an email from Douglas which contained the requested information. Now, why would something go, if Maori is putting it in, why isn't Maori getting back the email, right? But it's going straight to F.A. Douglas, who received it on June 27th. And then Maori on July 5th, 2023, he received an email from Douglas, which contained the requested information. Okay, ready? And he signed it. Awesome. This is the search warrant. Right here, Lawrence Maori, having given proof, upon oath this day, showing probable cause, establishing grounds for issuing a search warrant, and probable cause to believe that there is information regarding the crimes of homicide and burglary occurring at 1122 King Road, Moscow, Idaho, on or about November 13th, is on the following Amazon accounts, plural. For March 20th through March 30th of 2022. Now, we know how Maori and Payne, how they do things, right? It's copycat paste. It's copycat paste. It's copycat paste. Like, shit, they'll fuck it up and have, this is the affidavit of Maori, and I, Corporal Payne. It's like, what the fuck y'all doing? So we know that they are notorious for copycat paste, that they don't pay attention, and that they're just, I'm sorry, sloppy as fuck. We know this. So March 20th through March 30th, right? And November 1st through December 6th. Ready? Why not December 29th, 2022? Why? Do you guys remember what Ann Taylor and company have said, specifically Elisa Massis? Remember there talks about a federal grand jury? Remember those talks? Well, I'm just going to give it to you right here. December 6th, 2022 is the day before December 7th, which they are asking for tips or leads for a white Elantra. Okay, right? The public. Okay. So the public is being asked on December 7th, tips / leads. We want, 2011 to 2013, right? But wait a second. Wait, this was filed May 8th, Lana? Yeah, May 8th. May 8th, 2023. Okay, follow me. And so Maori's doing it, right? And Maori decides that he's going to ask for March 20th, 2022 through March 30th, 2022 and November 1st, but just until December 6th. Well, why wouldn't he need to ask all the way until December, to the point of Brian being arrested, right? Why would you stop on this date, right? You're looking for, here, customer name, customer email, shipping phone, to include all detailed customer click activity pertaining to knives and accessories. All details of payment methods, okay. All details of items in carts to include all items added to cart, okay. Why would you need to do this on May 8th? You wouldn't think that this would have been done way before this point? Of course it was. Of course it was. It was done by the motherfucking FBI. And it was done on December 6th, 2022. And Lawrence Maori, you dumb motherfucker. You copy, cut, and paste, and you never changed the date to December 29th, 2022. Because you got this information from the FBI. Because the FBI already did it. They already knew this information. Okay? They already knew this information. They gave you this information. And then your stupid ass didn't change this date. And then you guys try to make it seem like the FBI didn't have the information. Send the results on over to F.A. Douglas. And then F.A. Douglas sends it on over to me after that, because we had to send it over there because they don't have it yet, right? Right? Is that right? Is that right? I've asked when did they get the name Brian Kohberger? Well, the FBI, without a doubt, without a motherfucking doubt, had that name before December 6th, 2022. I got plenty more where this came from. We'll see you on the next show.
Listen, folks, I know there's a history here. I'd like to get this hearing in today. You know, everybody needs to just focus on the relevant facts, okay? I know there's a history here. I know.
Boom, bitch! Boom, bitch! Go get yourself some, Maori. Go get yourself some.
Are you talking up by Sunset, Martin? Up the hill by the gas station?
Yeah.
Okay. Why did you? All right. Who's responsible here?
What's that?
Who's responsible here? Whose house is this?
Yeah, I've been drinking or anything, right?
No.
Okay, drive careful, okay?
Thank you.
This is what the other group had that ran away.
Oh, really? You just ditched it? Awesome.
Yeah, those ones kept walking to the car and the other one.
It's truly for the win.
Disc that I was given to. So there was 2 different discs. Okay? They all knew about it.